Hi, this is Kowski, and in this video, we're going to be looking at the criminal justice amendments, and those deal with the 4th, 5th, 6th, and 8th amendments with respect to cases that you need to know, as well as other background information for the AP Gov exam. And let's again first start with the 14th Amendment, as it contains two very important clauses. The clause that's going to pertain most to the criminal justice amendments in terms of protections, since this deals with civil liberties, is going to be the Due Process Clause, which is going to declare that states may not deny any person life, liberty, or property without due process of law, meaning that, think of it as almost an assembly line, that even before you're even charged with a crime, you can have rights via your 4th Amendment, and that is of course known as your Privacy Amendment, because it protects you from the police and the government from going into your house without a warrant. And then if you were to get arrested, during that process, you're also, again, going to be protected, as you're going to see through the 5th Amendment, where you have the right to remain silent. And then when you're being prosecuted by the government, you also have a number of rights under your 6th Amendment. And that, of course, is going to cover you for having the right to a lawyer, to having a speedy and public trial. And these are important rights. And then you're also protected after, in the event that you are convicted. The government cannot, excessively fine you as per the 8th Amendment, or torture you, or do anything that's cruel or unusual. So, the due process clause is very, very important towards protecting your rights before you're arrested, while you're arrested, and even after you're arrested, should it come to that. The Equal Protection Clause, keep in mind, is going to be more for civil rights cases. That's going to be very important towards expanding rights in these liberties for disenfranchised parts of the population. But for this video, we're going to be focusing more on the effect of the Due Process Clause. And you're probably aware, you probably have heard of this before, the Miranda warning, which comes out of a Supreme Court case known as Miranda v. Arizona in 1966. And that's going to result in which the police are going to have to inform any suspect who's arrested or being questioned at any point by the police that they have their right to remain silent and their right to counsel. And counsel means your right to an attorney. So, this happens under Chief Warren's court in the 1960s. And Warren is very known for being an activist court, expanding civil liberties. And in this case is no exception here. And here you see on the right is Ernesto Miranda. He's arrested, and basically he's going to challenge that he should have been informed of this 5th and 6th Amendment right. And the fact that the police in all 50 states, all states, municipalities, you name it, have to inform you that you have the right to remain silent. And if you choose to talk and give up that right, what you say to the police right then and there can be used against you in the court of law. And then they also have to inform you that you have a right to an attorney. This also has been expanded to, if you don't speak English, they have to find a translator and be able to translate this to the native language that you speak. Now, of course, there is an exception to this rule. This is known as the public safety exception. And basically, this allows statements before suspect has been warned of rights based on protecting public safety. If questioning is to prevent a dangerous situation and the suspect responds, it can be used as evidence regardless of the Miranda warning. So, think of it as in this sense, that if you've been arrested and let's say there's a ticking time bomb somewhere and the police are asking you, where's that bomb, right? There's the public safety exception. They're not going to say, oh, let me read you your Miranda rights before it's too late. Again, there are exceptions, but by and large, you do have to be informed of your rights. And you'll note that this uses your 5th Amendment right, the right to remain silent, and the 6th Amendment right, your right to counsel or a lawyer, through the due process clause when you are getting what's called Mirandized. And again, as I mentioned, this is falling under the Warren Court. Now, the next part is our 6th Amendment, and this contains various parts of your rights in the 6th Amendment, amongst several others. But again, your right to legal counsel, a speedy and public trial, as well as an impartial jury. Now, this is going to culminate in another Supreme Court case known as GIDEON v. Wainwright in 1963, once again under the Warren Court. And at this point, Clarence Gideon, as you see here, is a limited education in his background, and he's charged after allegedly stealing and breaking into a pool hall, something around the sum of about $5, and he's sentenced to prison, and he can't defend himself in court. And while in prison, he begins to study the law, and he's studying it, and he actually is going to petition the Supreme Court and say, you know what, I have no legal background, I have no very limited education, and I cannot defend myself. And my Sixth Amendment right to a lawyer should have been given to me. Now, keep in mind, at this point, the right to a lawyer really just pertained at this point to capital offenses like murder. He's not wanted or being charged with murder. He's being charged with theft. And he's saying, I can't protect myself, and that this should be a fundamental right. And it's because of this case that the Supreme Court agrees, and this creates the right to counsel or public defenders. So they have to be provided in criminal cases as per the Sixth Amendment right, Sixth Amendment, and this is going to be considered a fundamental right. Now, it's important to keep in mind that this only applies to criminal cases and not civil cases. So if somebody's suing you for a monetary amount, you're on your own. This only pertains to, again, criminal cases, because the idea is your liberty is at stake. Money can hypothetically be replaced, but your liberty can't. If you're put in prison, you can't defend yourself, that's a problem. And so as a result, this is the case that's going to create public defenders, and certainly they play a very, very important role in our criminal justice system. And once again, the Due Process Clause is utilized here. Now, moving on to the Fourth Amendment, before you're ever arrested, as we see in Miranda, and before you ever need a lawyer, as we see in Gideon in the Sixth Amendment, there's a case, and you don't need to know this one, it is not required by the AP Gov people at the College Board, but what comes out of MAP v. Ohio, you do actually need to know. And the long story short is Dorleen Mapp is in her house, and the police knock on her door, and they say that they're looking for a bombing suspect. And they ask to search her house for that suspect. She declines, and the police basically make up a warrant, and they enter in her house. And in the course of looking for the so-called suspect, they come across a trunk, and they open it, and it's filled with bunches of material. Now, keep in mind, they're looking for a suspect, but they decide to go through the trunk anyway. And what Dorleen Mapp actually has is pornographic material that was outlawed in Ohio. Keep in mind, we're in the 1960s at this point. Not illegal anymore, obviously. But she is arrested, and she's charged. And she's going to argue, and again, this is going to culminate up to the Supreme Court, that they did not have a warrant to search her house. Remember, they were looking for a bombing suspect. They basically wrote on a piece of paper and made up this warrant that was never really signed or seen by any judge. And her case is going to establish what's called the exclusionary rule, that states that evidence that is illegally seized by the police, such as they didn't have a warrant in the first place, that violates the Fourth Amendment right from unreasonable searches cannot be used against you in court. So hypothetically, if you had a meth lab and the police bust it down and they don't have a warrant and they seize all this evidence, none of that evidence can be used against you. So that's why the police have to act very carefully, make sure all their T's are crossed and all their I's are dotted, as warrants are going to be required in most situations. But there are some exceptions. For example, if something was done in good faith, if there's what's called the inevitable discovery exception. And then even students at school are not necessarily entitled, such as their lockers. They do not need a warrant. So there are a few exceptions, but for the most part, this is a very, very important concept here, the exclusionary rule. Again, all evidence illegally seized has to be excluded in the court of law if you are going to be charged in that way. Now, the Fourth Amendment is very much changing, especially in the digital age, and there's an ongoing debate between Americans' freedom as well as their security. And one of the more controversial pieces of legislation that was also covered in Unit 1 was the Patriot Act. And of course, that allowed for the NSA to perform wireless wiretapping on people's phone calls. And that gets into a classic Fourth Amendment issue. Do we protect people's privacy, or are we going to be more interested in security? And during the times of war and national emergencies, you tend to see people's civil liberties begin to be dwarfed, and we saw that after 9/11. Another classic example with Edward Snowden and the NSA, their surveillance and their collection of metadata, where they're taking all cell phone communication information with the exception of the actual conversation. They're not listening, but again, they're going to see that, oh, this number called that number, and for this amount of time. So they're collecting all this data. Is that a problem in the digital age as per the Fourth Amendment? And these are issues that are constantly being worked out. But again, there's this careful balance that the Supreme Court is trying to maintain. And we've seen this with the Fourth Amendment. For example, with cell phones, if you get pulled over and there's drugs in your car and they arrest you, can they go through your cell phone? The Supreme Court has ruled they need a warrant. Can they put a GPS on your car without a warrant? No, the Supreme Court says you have to. And then, you look at the Second Amendment, on the other hand, with McDonald versus Chicago, which we covered in another video, which is going to strike down a lot of handgun bans, which allow people to protect themselves. So again, it's this classic balance between people's rights and the safety of the public. Last slide here, our Eighth Amendment, and that, of course, protects you from cruel and unusual punishment, as well as preventing excessive fines and bail from the federal government and state governments here. So capital punishment is permissible, and when we're talking about that, we're talking about the death penalty under the Eighth Amendment. There was a brief moratorium in the 1970s that was once lifted after the Supreme Court concluded that it did not constitute anything that was cruel or unusual. Now, states can restrict the practice, as we see in states like New Jersey, New York, Maryland, Connecticut, a lot of northeastern states and northern states, but you also have a lot of states that still have it, whether that's Florida, California, Texas, etc. And the main method, of course, being used is lethal injection. Now, the limitations as to who can receive the Eighth Amendment have been used over time to prevent certain demographics. For example, juveniles. If you're under the age of 18, when you committed the act of murder, you cannot get the death penalty. And that comes out of a very famous Supreme Court case that you don't need to know for this exam, but Roper v. Simmons, if you're interested in looking it up. Also, if you're mentally ill, that prevents you from getting the death penalty in Atkins v. Virginia. Or if you're physically ill. What's interesting is if you are sick, let's say you have cancer, and you've been convicted for 10 murders in, let's say, Texas, the law says, and the Supreme Court has interpreted it, that it's cruel and unusual punishment to execute a sick person. But let's say that person who has cancer gets better, then the law says the state can then execute them. So it's a little interesting in that case. That doesn't happen all that often. Also keep in mind that the death penalty can only be used for capital crimes only, such as murder. It cannot be used for heinous things like rape or child molestation. It has to be for murder. So there are limitations as to what capital punishment can be used for, as well as who is eligible to receive it. But again, when we think about our criminal justice amendments, we're thinking about the Fourth Amendment, right, with respect to your privacy before you ever get arrested, have any contact with the police. The Fifth Amendment, that's the process when you're interacting with the police or government, the right to remain silent. The Sixth Amendment, if you get arrested, right, you have due process in terms of having a speedy and public trial, having your right to counsel, maybe even a public defender based on your income. And then your Eighth Amendment, protecting you after you've been convicted in terms of protecting you from cruel and unusual punishment. So that's your criminal justice amendments that you will need to know for the AP Gov exam. And moving on to this, we'll move forward with other examples that was